Thank you. Now, sorry, lost my place there. Mr. Genis.
I'm very much a trial lawyer. I do a lot of drinking and driving cases. I deal with the 11B quite often. What my colleagues have said about the minimums resonates very much with me. Drinking and driving cases are the ones where the Parliament has prescribed minimums. An example of how that minimum would operate: if we have a student who came to Canada from overseas on a student visa, if he's convicted of drinking and driving, he's deportable. By way of example, if a Canadian is convicted of drinking and driving, he can enter the U.S. It's not considered to be a crime of moral turpitude in the U.S. If an American is convicted of drinking and driving, be it in Canada or in the U.S., he is inadmissible to Canada. So it's not symmetrical as it is. I think the consequences for drinking and driving are harsh as they are. It surprised me, therefore, a little bit to read in the Senate's documents about the British Columbia initiatives and about how they managed to take cases out of the court system, drinking and driving cases. I think the interests and positions on that are quite far apart. On the one hand, we want drunk drivers to be punished very severely, and we certainly do punish. On the other hand, somehow we want these cases not to clog the court system. I would think that giving more discretion to the Crowns would help a lot. I think they used to have more discretion than they have now. But that, I think, is a good example of how the task of that committee is not very much an enviable one. It's a hard task to deal with these delays issues. There is way more questions than answers. A couple of other examples just to throw it out there, and these are cases of mine that have been adjudicated. I've got more of which I cannot speak because they are still before the courts, but a couple of examples. One client of mine had a situation where his case has not been reached for trial 3 times. What it means in Ontario Court of Justice, cases are routinely overbooked in anticipation of guilty pleas, in anticipation of sick witnesses, sick lawyers, sick clients, whatever the case may be. Way more cases are booked than there are judges prepared to hear these cases, and that is okayed by the courts. That is considered to be normal and appropriate because of the statistics, right? But one client of mine had to come to court 3 times on a simple case, very straightforward case, hiring a lawyer for each and every, paying a lawyer for his trial date for each and every time because his case just hasn't gotten reached on each occurrence. And now, in light of Jordan, it's interesting to see that in fact, all these 3 appearances managed to have happened within the 1.5 year. So I was lucky enough to win this case on the merits, but 11B-wise, my client, even though he had to pay me 3 times to appear, would have had an uphill battle asking for a stay based on the delay because he was just under the 1.5 year. Another example of a case that also makes you scratch your head is I had a client who is a foreigner. He was accused of drinking and driving here in Canada. He comes to Canada on business from time to time. He had to come specifically for his trial a number of times from overseas, all the way from Europe. And the trial didn't take place for different reasons. Once there was no interpreter, and who has been ordered. There was an issue. It's a bureaucracy. It's still an issue. Things fall through the cracks. right? He has to come a number of times, and it was just before Jordan that the matter has been adjudicated. Had it been post-Jordan, this client would have had a significant difficulty asking the court to stay the charges. So there is way more questions than answers. I will admire any good solution to any of this, but these are very complex issues. And I'm speaking from the trenches.
All right, thank you.